Going to start now, and then we're going to do a 3, 2, 1.
For the audio.
And we are ready to go live for audio in 3, 2, 1.
Welcome to another episode of Business Buzz.
All right.
We are ready to rock and roll today. All right, so we're in the offices of Mr. Andy Cook, family law attorney. All right.
That's correct.
And first of all, thank you for coming on the show.
My pleasure.
Taking time out of your busy day to jump on a show with two dudes. And we want to give a shout out to Mr. Ryan Lipsey, because you came highly recommended from Ryan. He said you're a great guy, and I should definitely get you on the show and talk to you about what it is that you do. So shout out to Ryan. You got anything to say, Mr. Lipsey?
Well, I haven't seen him for a while, but he is a good person, and I send him my best regards.
Awesome. All
Hey,
right.
I'm just curious. When did you meet Ryan, and how long have you known him?
I would say I've known him for about 2 years, approximately. That would be my best estimate.
2 years. Yeah, I mean, Ryan has been one of our great supporters since we started doing a podcast back in July. He's helped us reach out to a number of people, and so we're thankful for him. And then thank you again for being on the show. So let's get this thing rock and roll. Are you ready, Andy?
I certainly am.
All right. So Andy, tell me a little bit about what you do.
Well, I'm a certified family law specialist, so what that means is I do family law. I practice in that area exclusively. Family law means divorce and the issues that are part of divorce cases, like child custody, child support, spousal support, property division, and if appropriate, handling issues of domestic violence. And then I also handle post-divorce matters, which sometimes arise because there's a need to modify orders regarding child custody or spousal support or child support. And then a number of other issues like paternity cases, which are cases where there are children but the mother and father were never married. So if you add those areas up, that pretty much is close to 95 to 98% of what family law encompasses for me. I also do prenuptial agreements.
So you do the before the marriage, during the marriage, and after the marriage.
Well, that's one way to look at it. Yes, yes.
No, that's some. I mean, I'd imagine you stay busy. I heard a statistic somewhere. I don't know how true it is, but half the time when you go into a marriage, you're going to end up meeting a divorce attorney.
Well, I've heard that too. I'm not sure if it's true or where those statistics come from, or whether it's just California or the entire country or the entire world, but it is a constant factor in life. It's one of the more stressful things that people who experience it have to experience it, along with, I think the other two were, death and of a loved one, and losing a job, which can also be very stressful. So it is something that is a very important part of people's lives.
And would you say that a lot of these things come hand in hand? Like, I mean, God forbid, death of a child or death of a close family member, or being in a position where finances become an issue. Those types of situations, stressful as they are, tend to lead to separation of marriages from time to time, or very often in your case. Would you agree, or is it a little bit different? What's your experience?
No, I think that those factors do play a role. They don't explain every divorce, but they explain, a good percentage of them. Fortunately, we don't have a lot of cases where someone has lost a child, but I've had some of them, and that can cause the marriage itself to fall apart. The loss of another loved one, that's probably less common. In other words, if someone dies of old age, that doesn't usually prompt a divorce, although I suppose it could. But there's a multitude of reasons. In California, as is the case in most states, you can get divorced for any reason, and only one person has to one out. That's correct. Mm-hmm. And so in California, the standard is irreconcilable differences, which is a vague term, but it's deliberately vague because the courts are generally not concerned with why the marriage has broken apart, although sometimes that does sort of provide the answer to why the parties are arguing about some other issues. But in general, you can get divorced for whatever reason or really no good reason. And once the people, or at least one of the parties, decides to get divorced, that's when I get involved, unless I was there to do a prenuptial agreement.
Yeah, so if you were there ahead of time, they're of course going to call you when it's time to get over with, because they're going to want to execute this prenuptial plan.
Well, actually, though, if I do a prenuptial agreement, I can only represent one of the parties in the drafting of the prenuptial agreement, and then I probably can't serve as a witness in any subsequent divorce case because of the general ban on a lawyer also being a witness in court. I mean, it's not in the same case that the lawyer is providing representation. It can happen in certain cases, but in a prenuptial agreement, you can bet that it's not a good idea for the lawyer to both be the drafter of the prenuptial agreement and a witness in the trial. And let me just expound upon that a little bit, because if there is a divorce, then one of the issues in the divorce is going to be whether or not the prenuptial agreement was valid, and the lawyer may have information about whether or not the parties, or at least one of the parties, understood the agreement, what the terms were in terms of what time of day it was signed and under what type of pressure. And so that's fine. The lawyer can certainly testify in that regard, but then for that lawyer also to not just testify, but also be that lawyer's that client's lawyer at that time, that's awkward, and so generally I wouldn't do that.
That's kind of funny, actually. So coming from a divorce attorney, you don't want to put yourself in a precarious situation.
Well, yeah, I mean, I think in any case where the lawyer is a witness, it's just not a great idea going forward for that lawyer to also be the lawyer in the case in which the lawyer is going to be a witness. It's allowed in certain cases, especially if the client gives a certain type of consent. I don't have the exact language memorized, but any lawyer should know about that problem or that issue and look seriously at it before testifying as a witness in the case that the lawyer is providing services in.
All right. Let's get into some nitty-gritties. Common misconceptions, for example. So a common misconception is that when a husband and wife split up, that the guy always gets screwed. Is that usually the case?
No, it's probably the case maybe 50% of the time, and I'm not sure if that would be the right way to describe the situation. Historically, men made more money than women, and so when it came time to provide support, the man would be paying support to the woman, not just because the man was making more money, but because traditionally women, either just because of general beliefs or because of the fact that they weren't in the workplace to the extent that they are now, would be more likely to get custody as well. So if you have custody and you are the lower earner, that means that you are more likely to receive support than have to pay support. But the reality is that men receive spousal support now if they are the low earner and the spouse makes significantly more money, and lots of times men get custody, and in fact it's mandated that they get custody in cases involving domestic violence perpetrated by the other party, unless the other party can prove that that law should not apply. So in general, to get back to your original question, no, a person may not like the outcome, and if that person's a man, that person may start telling friends that he didn't do very well because of his gender, but that's not the way it works, and most judges don't think that way.
All right, so if we're going through a separation, does it mean that because mom's a mom, is she more likely to get custody?
No, as I said, the court really has to look at what's in the best interests of the children, and so a lot of it is just based on timing. If the parties have been separated for a while, that is,
Living apart.
A court will look very closely at the status quo. That is, what is the arrangement from the time that the parties stopped living together until the time of the court hearing. And if one party has the child or the children significantly more, then that person has an advantage over the other party, regardless of whether that person is a man or a woman. The other thing is that, yes, frequent and continuing contacts, which is what the family code describes that scenario as. In other words, you look at the status quo, but you also look at the goal of both parents having frequent contacts with the child or the children. The number one factor is the safety of the child. So any issues regarding abuse of alcohol or use of illegal drugs sort of trumps everything else, as does any history of domestic violence, either against the child or between the two parents. So you've got to get past that issue, and once you do, then you just look at the overall best interest, frequent and continuing contacts, and the issue of what the status quo is.
All right, next toughie question. You ready? So another slang thing that I've heard all the time is it's cheaper to keep her or it's cheaper to keep him. So that stems from the whole, who gets to pay alimony and who doesn't get to pay alimony, who gets to receive it, who gets to pay child custody. Assuming that the spouse stayed at home, regardless of gender, just spouse stayed at home to take care of the child, does that automatically mean that spouse is going to end up receiving alimony?
No, because there could be a number of reasons not to award spousal support, which is used the same way that we use the word alimony. First of all, if the person who works outside of the home does not make a lot of money, then there may not be enough money to award spousal support. I'm assuming in this case that there are children involved. Or if the marriage was very short, then even if spousal support is awarded, it's going to be for a very short period of time. So you've got to look at a number of factors in terms of the argument that it's cheaper to keep the person than not. You do have to look at that when deciding to get a divorce. It doesn't make people rich. There's certain types of lawsuits outside of family law where at the end of the day you might get a big payout, and usually those cases involve some type of harm like wrongful termination or personal injury. But my point is that rarely in family court do you walk out of there feeling like you just made $1 million, because you don't. And so you need to think carefully before you get married, and then once you do get married, about getting divorced. So I don't decide for people whether they should get divorced or not. That's up to them. But once they do make that decision, that's sort of when I come in.
When you step in.
When I step in. So I'm always reminded of a episode. I hate to do this on a legal interview like this, but I think it was Inside Edition a number of years ago. And the reason I make this point is it's not just the people who don't have a lot of money who suffer through a divorce, but wealthy people as well. They were doing a story on the cast of All in the Family, and they were interviewing the son. I guess that's Rob Reiner, not Carl Reiner, who's the dad. And they asked him, because at a certain point in the production of the show, he left the show. He was written out of the cast at his own request, and they asked him why he was doing it, and he said, "It's a good question. I was going through a divorce, and so I could have used the money. And so it just shows you that even somebody who is in Hollywood and is working in the in the entertainment industry and presumably has a lot of money, even for them, if they're going through a divorce, it is going to pinch a little bit.
Yeah.
And it's all relative. If you make less money, you may have to pay less money, but that's still a lot of money
compared
for that
to your
person.
check. Yeah.
So it is not a cheap thing to do, and something that people need to think carefully about.
Well, let's stick to the celebrity status. So recently in the news, we had Jeff Bezos, owner of Amazon. It's said to be probably the most expensive divorce that's going to be happening in that situation. And we live in a community property state of California. So when it comes to, separating assets, is there like a time frame? Is there like, does a prenup help us separate things? Or is it from the moment we get married, everything we have growing from that point is community property? How does that work?
Well, it is true that a prenuptial agreement can override California's community property law. And by the way, there are about 9 states in the United States that are community property states, and we're one of them. So the way it works is that community property is property that is acquired by a married person or by married people while they are living in California, and they acquire that property after the date of marriage and before the date of separation. And there's certain exceptions, but that's the general rule. One of the exceptions, for example, is if you acquire an inheritance during marriage, that's separate property. So there are some exceptions. Now, if you don't like that concept, you can enter into a prenuptial agreement. In fact, really the 2 reasons that people go into prenuptial agreements, number one is they don't like the rules of community property, and so they don't want that to apply. And number 2 is to eliminate the possibility of ever having to pay spousal support. You cannot eliminate the possibility of having to pay child support because the child is a minor.
You're looking in the interest of the child,
right?
In that case.
And the same thing with custody. You can't say if we get divorced, I'm going to get every Wednesday and every Friday. That would not fly with a court when it came time to enforce the prenuptial agreement. But so basically, you have to look at when do they get married, and then when do they separate? Not when do they get divorced, but when do they separate? And if the asset or the debt was either acquired or incurred between those 2 times, there's a very strong possibility, and in fact a probability, that it's going to be deemed community property. And so that is how community property in general works. And so if you have a job, let's say, and you're engaged to get married, and a week before you get married, you get your paycheck, that's your separate property. But then the next time you get paid,
you're married.
Assuming you get paid, let's say, every other week, that's community property. And then if you separate on a Friday, but you got paid on a Wednesday, that's community property. But then when you get paid the next time, it goes back to being separate property. But what happens is that it's not that this money just accumulates because you both get community property and you spend it during the marriage. So you have to look at that as well.
Oh, that's great, because that was one of our questions from one of our Facebook fans. He was asking about, when it comes time to get a divorce and you have acquired debts, what's the best way to minimize damage? And I think the way you're answering that is you get a prenup, so you can decide ahead of time how debts and assets will be allocated upon a divorce.
Well, that's one way to do it, although my guess would be that most people don't get prenuptial agreements, so you have to look at what does happen with debt when people do get divorced. And again, it's like community property assets, except it's community property debt, and so the debt has to be evenly divided. So we've talked a little bit about how to define community property, but then I guess the other issue is, what do you do with that community property? And the answer is you divide it evenly. And the judge basically has 2 choices. The judge can divide things up by saying, okay, you get this, but the other party is going to get that, or we're going to split this in half. You can do that with money accounts. Like if there's $500 in the bank, the judge can say you each get $250. But you can't do that with the house. You can't,
You have to
chop
sell
the
that
house.
asset.
You can't chop the house in half, and so you offset things. You say, all right, you get the house, which has so much in equity, but I'm going to give the other person all this other stuff to make up for the fact that he or she is not getting the house. You mentioned selling the house. That sometimes is what happens as well, and the parties could split the proceeds. So there's a number of ways to divide community property equally. Sometimes, for example, if there's debt and there's assets, the judge can award the same person both an asset and a debt because it's a wash.
Yeah.
So that can happen too. There are a lot of ways that it can happen, and it's more complicated than we could possibly.
Oh yeah, because the scenarios are endless at that point.
Right.
Yeah,
So,
I was about to actually throw a scenario at you, so this is kind of a weird one. What if someone had two people are married, and both their names are on the title of a car, but the loan is only in one person's name? How does that work for community property?
Well, if the vehicle was acquired during marriage, which is sort of the way I always started, that's in most respects that's going to be more important than title, at least under the recent cases interpreting community property. Let's assume that it's community property. You go with the fact that it was acquired during the marriage, and under your scenario, in addition, both people are on the title, on the deed to the car, or on the title paperwork to the car. So it's community property. And so the fact that the loan may only be in one person's name is not going to affect what the judge is going to do with respect to the car or how the car is valued. But if the car is awarded to the person whose name is on the loan, or we'll start with that scenario first, then that person is going to have to hold harmless the person who does not get the car. And if for some reason the car were to be awarded to the person who's not on the loan, then as a condition of that person getting the car, that person might need to refinance the vehicle so that the person who's on the loan is taken off the loan and the other person is put on a new loan for the car.
that makes sense, and that has to be, it's pretty much negotiated between attorneys and finalized by a judge.
Well, yes, if it's negotiated by the attorneys, the judge will usually, but not always, just sign off on it. The judges are busy and they can't second guess
everything
and say, what would I do if I were one of the attorneys or one of the parties? If the parties and their attorneys cannot work something out, then the judge has to decide it. But usually on some of the smaller cases or on some of the smaller issues like cars, the parties are able to work it out ahead of time, especially if they have attorneys. In divorce cases, unlike civil cases or criminal cases, you sometimes can get a judgment or an agreement on some issues, but then go to trial on those issues that you couldn't agree on. It's not all or nothing.
Okay. Let's go to children in this case. We're told that sometimes life insurance policies are enacted or required when we have a divorce case that has some sort of child support or some sort of long-term care type situation. Is that something that's usually mandated by the court that happens to ensure that the financial aspect for the child is taken care of?
Well, I'm not going to say that courts will usually order somebody to acquire insurance that they never had to begin with. As a practical matter, a person may not qualify for life insurance, especially if the health is a little bit questionable, or the premiums might be very high. But you're more likely to see it when the parties negotiate a settlement, and they might say, okay, you're going to be paying me support, but if you die, then I don't get the support, so I want to have a life insurance. It's very common in the military for a number of reasons. One, there's the risk that service members undertake, but
Yes.
secondly, they tend to be younger, and so and the children tend to be younger, so what's at risk is far greater than two people in their 80s who get divorced, where the life expectancy
Right.
isn't going to be as long. But you do see that issue of a stipulated judgment requiring somebody to maintain or get life insurance, regardless of whether you're talking about child support or spousal support or both.
Oh, okay, cool. Because I want to make sure. Yeah, I mean, we hear the thing about law is everybody watches these shows on TV and they see like the Judge Judy's and they think, oh, that's easy. I can be an attorney myself. So when it's time to get, separation, they tend to come to some sort of written agreement between the two of them, and then they file their, paperwork, and then they assume everything's going to go hunky-dory down the road. What would you advise to people who end up going that route, who just come up with an agreement between the two of them and sign it?
Well, I don't know that would really be enforceable. In California, and again, I wouldn't be surprised if there weren't similar rules in other states, but in California, in order to get a divorce, especially if it's settled outside of court, each party has to complete what's called a declaration of disclosure, which is a revelation of their assets and their debts. And you would think that if people are married, they would know everything there is to know about the other side. But in certain cases they do, but in many cases they don't. And so anything that's written out on a sheet of paper or on the back of a napkin, that's not going to be enforceable. I can't be absolutely certain that every judge would agree with this, but it's not going to be enforceable, certainly at the moment it's written, because the court doesn't even have jurisdiction yet. Someone's got to file for divorce, and then even after the filing, there has to be these exchanges of declarations of disclosure, and you have to file with the court proof that you've complied with the declaration of disclosure requirement. And only after then can you enter into a binding judgment, and even then it's got to be written up in a way that reflects a certain amount of clarity. I mean, a handwritten agreement or something written on a yellow sheet just isn't going to do. I would also say that people just shouldn't do that in general, because you should talk to a lawyer first, because it's very hard to spot issues that you don't know exist in the first instance. So that goes with just about any area of the law. I mean, for example, in criminal law, a person might say, well, look, I didn't do the crime. I'm innocent. I'm going to talk to the police. What do I have to hide? And that might seem to be perfectly common sense, but any good criminal defense attorney will say, even though you don't have anything to hide, you don't have anything to gain by talking, and if you do say something that's a little inconsistent, you might cause suspicion about yourself, so don't do it. And the person may not have thought about that unless he or she spoke to an attorney. Well, the same thing works in family law. You can certainly talk to your spouse about some general goals, in terms of custody, but in general, you shouldn't commit yourself to any specific agreement. And then, as I said, even if you did do that, it may not be enforceable anyway.
Yeah, so I'm thinking, let's say you do come to an agreement and you both agree. Of course, you're coming to this agreement like you did when you got married, and you're assuming that it's going to work out just like you assumed it was going to work out when you got married. And then a few years down the road, you figured out that your agreement didn't work out. So what's to say this post-nuptial agreement won't work out? Then one spouse can come back and say, hey, I want more, or I want something else, and then see an attorney, and it could just all be, it could be more expensive if you didn't do the attorney route the first time.
Right. I mean, so again, there's nothing wrong with reaching an agreement. You can hire an attorney and say, this is what we have agreed to. The attorney can write all of that down, And then as the case progresses, the attorney can contact the other attorney and say, it's my understanding that the parties have agreed to this and to that, and the case can go on that way. So we're not here as family law attorneys to create rifts or problems when they don't exist. But sometimes people will agree to something and they won't realize how deep a hole they're digging for themselves. Excuse me. And so you just have to be careful. But as I said, I think, you shouldn't be afraid to talk to your spouse unless there's a domestic violence situation, because, talking does lead to agreements, and agreements are always better than fighting it out in court. You should still talk to an attorney and get legal advice, but if that doesn't mean that you need to make it a replay of World War II.
Right.
We got time for just one more question, and I'm going to throw this one at you really quickly here. How does infidelity affect stuff like community property, alimony, child support, etc., or does it?
Well, it generally does not. So there's a couple of issues there. First of all, as I said earlier, the standard for getting a divorce is irreconcilable differences. And it doesn't matter whether those irreconcilable differences are due to alcoholism, financial pressure, depression, or infidelity, or any other number of reasons. If the parties have no children, it's even less important, because for the obvious reason that if there are children, and if the children are witnesses to the infidelity in a somewhat graphic way, and if the children are young, I mean, when you add all that together, I can't say that it never plays a role ever, but generally it does not, because first of all, if the children don't find out about it, then it's not really a factor.
Not relevant.
If there are no children, then again, it doesn't really play a role in the division of property or spousal support, or how you define community property. The one time that it might be a factor if there are no children is if one of the party who's involved in the adulterous relationship is funneling money or paying for we'll say the third adult's lifestyle, whether it be rent or things like that. But it's a difficult call. If for example, we'll just call it spouse one is having an extramarital affair, and that affair, besides the sexual nature, which doesn't really generate, a dollar cost, they're eating out at fancy restaurants. We'll say the most fancy restaurant in San Diego. Do you say, okay, well, that obligation, you've breached your fiduciary duty, and we haven't talked about that today, but that's one of the consequences of being a financially dishonest person. If you go out to an expensive restaurant, does that with your with the person you're seeing, does that count? And I'm not sure that it does, because if you went out with your brother to the most expensive restaurant and ordered food and drinks that you really probably couldn't afford, that's
choice,
fine.
yeah.
It's a choice, and you're not going to be punished for it. Where it would play a role, though, is the spouse is writing a check for that person to live in an apartment someplace else, because that's clearly something that the cheating spouse is not benefiting from, and the community is not benefiting from, and it's simply being written to someone who's the person's not married to. But the actual act of the sex is not relevant, especially when there's no children, and unless you're diverting funds to pay for the new significant other. So in general, it doesn't. It's not a factor.
Well, all I can say is I learned a lot today.
Ditto. This is probably one of the most educational podcasts.
Yeah.
So thank you very much for that, Mr. Andy
Definitely. Yeah. I mean, I threw some myths at you. You helped me clarify them because, there's always, you always know people who are going through a situation. And once one happens, you tend to know the other ones. And so now I know exactly where to refer them to.
Well, I appreciate that. And remember, don't listen to your friends. Everyone's case is different.
Mm-hmm.
And if you are going to make that mistake, and listen to your friends, make sure they're California friends, because obviously the law is different in other states and certainly in other countries.
I like that. If you're going to make that mistake.
Yeah, don't make the mistake to begin with. You can talk to, misery enjoys company, and you can sort of commiserate together, but don't assume that what's going to happen in one case is going to happen in another.
Great assumption. Great. What did we say about assumptions? They make an ass out of you and me. So,
yeah, we kind of did that today a little bit.
Yeah, exactly. Well, Mr. Cook, thank you for taking the time to be on the podcast. I mean, we learned a ton. And, I work with a lot of real estate agents, and real estate agents have roller coaster incomes. And when you have roller coaster incomes with married couples, they tend to be some problematic issues. So if anybody needs your services, make sure they reach out. Do me a favor, Mr. Cook. Point to the little screen right here. Point down on your screen.
Okay.
That is your contact information. So if anybody's watching this on when we post it on Facebook, they can contact you right there. Take the last little minute here, talk to the camera, let the people know how they get a hold of you if they need your services.
Well, the best way is to call at 619-515-9900. They can also check us out and reach out to us on email at acookjd@earthlink.net. Our website is divorcesd.com. And I guess what I would say is, besides the normal business hours that we keep, I'm one of those people who believes that I'm always on call. And so when I travel, or even when it's the weekend and I'm here in San Diego, I check voicemail periodically. 7 days a week, check email several times a day, even when I'm not in the office. So if you want to reach me, you'll be able to do so.
Awesome. And then lastly, we always put our guests on the spot. Who do you think would be a great podcast guest who can share some information that you've worked with in the past in business or in any type of industry?
Well, that's a tough question. You may have finally stumped me at the very end. I'm gonna maybe take a pass at that one, just because you're asking about a specific business category, and then who does the best job in that business category. I come from a medical family. My father is a retired physician, and my brother is a practicing physician. So I think if you got a good medical doctor, an internist, that would be a great person to talk to, because after all, if you can't live, then
what's the point?
The divorce probably doesn't matter anyway.
Exactly.
So let's go with a doctor.
All right, sounds good. Then maybe I'll hit you up a little bit later. Maybe we can get your brother on the podcast. We'll see.
Well, he's in New Hampshire, but you're certainly, if you don't mind the cold, you can
fly out there.
We'll
see about that one. Thanks again, Mr. Cook, for coming on the podcast. We really appreciate your time. I know your time is valuable. You stay busy being in a beautiful city with a lot of temptation. So I'm sure your calendar stays booked, and I appreciate the time slot that you gave us.
Thank you.
All right. That's all we got for you guys today. If you guys want to reach out to Andy, his contact info is on the screen. If you guys want to be on the podcast, turn on at csfirst.com. For all your insurance needs, James at csfirst.com, or you can follow us on our social media at Business Bros Pod. That's all we got for you guys today. Peace.
Bye-bye.
And we're out.
And thanks again, Mr. Cook.
Thank you.
That's it.
All righty.
Easy. So what'd you think?
No,